dared me to do that, so I did. Good afternoon. That was good, EMQ. Good afternoon, committee members and public. We have asked the Disability Law Center, the Office of Ombudsman for Long-Term Care, Office of Ombudsman for Mental Health, Developmental Disabilities, and providers to testify about the impacts that the aggressive fraud prevention measures have had on people accessing care and services. I want to get to the essence of continuity of care, right? That seems to be missing in the last 8 months where, I don't know, I was busy doing other stuff. We've heard plenty of stories in the news about how Minnesotans are caught in these actions, and we can't let that continue. It's about that individual. Today is about reviewing data and how the aggressive policies that are carried out without due diligence and thoughtfulness can harm the very people we aim to protect. It's our responsibility. This committee actually has been leaders in this forever. It's our responsibility to enact those safeguards that protect the continuity of care for people with disabilities, seniors, children, and families who depend on the services every day. I'm going to repeat that. It's our responsibility to enact the safeguards to protect the continuity of care. It's not a blame game. We're not here to blame anybody. Although if you want to start listing names, I can start listing those names. That's funny. But only in this committee, you know, this is about getting to the facts about what is happening to our loved ones and neighbors, and we will have to work together to ensure the accountability and compassion are front and center in the Minnesota Disability Services programs. So with that, members, I did embark on rearranging the order. We're going to start with Ellen Smart from the Minnesota Legal Aid, and why I thought that would be important is because she represents the protection and advocacy that is federally mandated to the state of Minnesota. Number two, we're going to go the Office of Ombudsman for Long-Term Care. Genevieve and Parache are here, and then we'll go to the presentation of the Office of Ombudsman for Mental Health, number 3. Number 4, we'll go with the presentation from the Residential Resources of Minnesota. Ken Bentz and Sarah are here for that, and then we'll finally have Matthew Bergeron come up, and that's it. If we have time, then we would take other folks that want to talk about it. We can do that. And members, do you want to wait until the presenters are done before we ask questions, or do you want to ask questions during the presentation? I know how this committee operates. I think we should wait till the end. Senator Edke got a thumbs up. Senator Fata, thumbs up. Glenn, thumbs up. We're good. So with that, Ms. Smart, welcome to the committee.
Thank you, Chair Hoffman. Thank you, members of the committee, for having me here today to talk about the work that Minnesota Legal Aid and the Minnesota Disability Law Center does.
Can somebody check her microphone? I can't hardly hear. I can't hear her at all.
Was I not close enough? That's it. So thank you for having me here today, Chair Hoffman and members of the committee. There is a legal aid office for every county in the state that handles civil legal aid cases for low-income Minnesotans. Mid-Minnesota Legal Aid, or MMLA, handles these cases in 20 counties and handles cases for seniors in 26 counties. However, the Minnesota Disability Law Center, which I'll talk more about soon, the Low Income Tax Clinic, and Project CARE, which are housed in MMLA, they take cases statewide. Project CARE is a team of healthcare navigators in our St. Cloud office that works to help Minnesotans find affordable health care coverage. Our low-income tax clinic helps clients with IRS and Minnesota Department of Revenue debt collection issues, as well as other issues like tax disputes and innocent spouse issues. These are the types of areas that Mid-Minnesota Legal Aid takes cases in. So I'd like to move specifically to take some time to talk about the Minnesota Disability Law Center because their work is what intersects the most with this committee. The Disability Law Center is Minnesota's Protection and Advocacy, or P&A, agency. P&A programs were created to protect and advocate for the health, safety, and well-being of people with disabilities to ensure that people with disabilities can live and work independently in the community of their choice. They have a federal mandate to keep people with disabilities safe from harm, fight illegal discrimination, and ensure that they have access to basic life necessities such as healthcare, housing, jobs, and education. The Disability Law Center represents clients in legal systems, in administrative hearings like DHS hearings, in state court and federal court, as well as advocates for clients in settings like IEP meetings and waiver meetings. Without P&As investigating, monitoring, and advocating, people would fall through the cracks. The P&A system was created by the federal government after the public learned of horrific conditions in state institutions. Many people P&As protect cannot advocate for themselves. So some of the cases that we work on, the numbers of cases that we work on each year are listed here. But what I'm hearing is that you really want us to get into some of the things that have happened in the past year. And the big impact with, first of all, there was the wave with HSS going away. Then came the ICS holds, and then came the prepayment reviews. But the biggest impact we're seeing is what happened with ICS. So since last year, MDLC has received about 56 calls from individuals regarding integrated community services. About a third of these issues are related to the payment holds, and 2/3 are related to what's going on with ICS agencies. So just to give you an idea of an example of each of these, with the payment holds, we have a 71-year-old client with multiple physical disabilities who moved into an ICS setting in the spring of 2024 after long-term housing instability. In October 2025, DHS froze payments to the ICS provider and they closed. His landlord gave him the option of staying, but his rent would increase from $300 to $1,400 per month. He only receives $1,200 from Social Security. Now here's an example where the provider's causing the issue. Jane Doe is a 43-year-old woman living with traumatic brain injury. She was not provided with any services upon moving in. She alleged fraud, stating that the timesheets were fraudulently signed to indicate that she was receiving services. While living there, she was propositioned by an ICS staff person, promising her rent in return for sexual favors. Her caddy case manager stopped reimbursement when the allegations came to light. Her ICS provider and landlord evicted her. She is now homeless. We all agree that fraud is horrible and must be stopped. But because of the ICS payment holds, 2 people have died, people have gone back to hospitals, people have become homeless, and people have gone to group homes, which is a complete rollback of Olmstead. Clients have few or no options if an ICS can't hold out with no income during these endless investigations and just shuts its doors. Individuals who need help finding new housing are not getting helped. If you've not seen the Carol Evans story about Janelle Hansen, who was current on her rent but was evicted because the ICS provider never paid the landlord, I urge you to watch it. At the time of the report earlier this month, she had been homeless for 8 months. Help was not coming. Even providers whose payments have not been frozen are so scared of the anti-kickback statute and how it may be applied, but we haven't seen how it will be applied yet, are raising rents. In the example I gave, by over $1,000, and that's not unusual. We have not seen the outcomes of many of these cases yet because nothing seems to be happening with these investigations, and there's no communication about what's happening with these investigations. Another issue with the ICS program is that it does not have the strong eviction protections that protect nursing home or assisted living residents, The leases are month to month, so anytime an ICS provider wishes to get rid of a client, they can terminate their lease, which is sometimes done out of retaliation. Strengthening eviction protections for ICS clients would help strengthen this program. Finally, we have a few suggestions for temporary fixes until the crisis settles down. One, we should clear the way for people to stay in their homes. Again, fraud is bad. We need to work on strengthening these programs and work on making this program better, but at least people are housed when they have ICS. Two, we should actually be accountable and provide support for people who have to move. And three, we should provide support for people who are lingering without services. There are ways we could tweak rules to allow services to come to people who at least are still have roofs over their heads. And finally, if you have constituents that need help or would like legal aid's help, this is a number that anybody in the state can call, and we can connect them to the county legal aid office that they're living in. Thank you very much for your time.
Thank you. In there, I saw, I guess, putting on your P&A hat, who is the person responsible? CMS has still in rule, the last time I looked, right? Continuity of care.
Yes.
Right? Must. It's not could or maybe but must, right? Is the language that there. Who's responsible for the continuity of care? And again, I'm asking you in your opinion, because you are a lawyer, who is that person responsible for the continuity of care? Who is responsible for an individual? Who's responsible for that individual's continuity of care in the state of Minnesota when they are under a waiver program? Who's going to be the person that's responsible, or what entity is responsible for that?
I believe that's Department of Human Services.
So if the Department of Human Services then is saying that, no, it's the lead agency, then you get into this finger pointing piece, right? And there's an individual that's an ICS person who there's weeks of back and forth when they knew that this person was going to be without services, and there was emails going back and forth saying this person's going to need services, this person's going to need services, and that never happened, right? And this is when I ended our committee hearing last week, brought it back to that aspect about where is that responsibility falling on, right? And so is there an opinion that P&A could give to this committee that validates that statement, right? A, or B, is there some language that we need to instill into our statute that says they are the sole responsibility for the individual? Because waivers are options, we know that, right? It's not one of the 11 mandated services under Medicaid, but it is an option. I think that would be something we would be interested in this committee of moving forward. And I saw the suggestions that you had in there too, right? When there isn't a transition plan in place, when there isn't eviction protections for the individuals, right, then they end up going, in the case of the individual that AJ Legou, Care 11, did, that showed that person knew for 4 months. I mean, that just absolutely set me aside, that there was 4 months of not one person came forward and said, hey, I have an option for you, right? And we're told, what are our options that exist up here in state statute? So the suggestions you have, are you putting that into a bill form for us to do on this committee?
We have not yet. We can certainly do that.
I think that would be something, clearly, when you talk about the responsibility or the welfare of a displaced individual, that falls on the state. And it was, when there's no protections, like nursing home protection, there's no protection in ICS, again, somebody has to help come forward on the continuity of care, and nobody's coming forward on that. And that bothers me. Members, any questions? Thoughts? You got a DHS question? Senator Wickland.
Yeah, thank you, Mr. Chair. I guess I was just wondering if, I think at a high level, the suggestion you have, Senator Hoffman, about clarifying in language, that's something to explore. And then I just wondered, with these suggestions that you've included, Ms. Smart, are they things that currently could be permitted, but, you know, they would need to have like additional resources for different areas to be able to do them, or would there need to be changes in like the service, the way the service is provided to allow, for example, like your second bullet point about allowing outside services to provide services if there's a point where an ICS provider is not able to provide their services. I'm just trying to get clarity on what already exists as a possibility versus what needs additional legislation to be able to happen.
Thank you, Chair Wickland. Ms. Smart.
Chair Hoffman, Senator Wickland, I believe currently PCAs and IHS workers are not allowed in ICS settings, so rules would have to be changed and CMS approval would have to be allowed to change the IHS rules.
Senator Wickland. Thank you. And you saw an increase too, the phone calls that your agency, were you able to handle all of those capacity-wise?
So far.
Thank you, Ms. Smart, for your time and for bringing this forward to us.
Thank you, Chair Hoffman.
We have now the Office of Ombudsman and Long-Term Care is here. Parache Rudina, Genevieve Gabrielt. I said that wrong, didn't I?
I'm happy that you're here to say it, Senator Hoffman.
So am I. Thank you. Genevieve, nice to see you.
Nice to see you. As we're switching information, I can start by introducing myself. I'm Genevieve, and it's pronounced Gaborio. Oh, that's a yo sound. Deputy Ombudsman for Long-Term Care, and I'm here with my colleague Parache Rudina, who is our legislative specialist. We're pulling up our slide deck.
I'm still waiting for some segue music, you know, when we do these transition stuff, you know. You'd think with all this technology. Glenn, we could hear like, you know, Six Fat Dutchman or Whoopi John, you know, they played in the backyard, right?
Senator Hoffman, it feels like maybe the Jeopardy music from this side of the table is more appropriate.
That would be good.
Thank you.
I think we're there.
All right.
All right, it's all yours.
Chair Hoffman, members of the committee, again, I'm Genevieve Gaborio with the Office of Ombudsman for Long-Term Care. Our mission is to empower, educate, and advocate alongside Minnesotans who are receiving licensed long-term care services and supports, and to ensure that their rights are upheld. We are a statewide service. We're a program of the Minnesota Board on Aging, and all that we do is person-centered. We get direction from the resident, what they want us to help them with, what they want to achieve, and we do our best to resolve it to their satisfaction. We primarily work in assisted living facilities and nursing homes, and there's plenty to do there. But we also have authority in any other licensed long-term care setting, including ICS. And that advocacy work that we do includes, as we're helping the resident get what they want, we're working with their facility, with the corporate leaders of a chain facility, with counties, case managers, the Department of Health, Minnesota Department of Human Services, and many more. And really trying to improve the system. And part of that work is testifying as we are today.
It just dawned on me, as you said, the Minnesota Department of Health and the Minnesota Department of Human Services, and I looked up, and I've never had this happen. Even when I was a lead, when the other team was in charge of this committee of the Department of Human Services. I don't see anybody here representing the Department of Human Services for any questions that we might have. I've never had that happen. Unless I'm not seeing, I don't see anybody here. That's kind of an embarrassment, actually. I mean, this is the Committee of Human Services, right? enough said on that. Thank you. I won't interrupt you anymore.
I'll move forward. Mr. Chair, members of the committee, I think, is there anything else on that slide? I think I can just, we can go to the next one. So what we're seeing is a small but increasing number of discharges or evictions in integrated community supports. What we see outside of integrated community supports is routinely missed services in assisted living facilities and nursing homes. Actually, our casework from 2023 to 2025, about 25% of our complaints are regarding lack of response to call lights, lack of care planning and follow-through, lack of incontinence care, and on and on. So a significant amount of our work is things that are not being provided that should have been. And just a note here that residents who pay privately in assisted living facilities have fewer reporting options because they don't have that additional case manager. They don't have someone from the county who is checking with them occasionally at least about services being provided. And so we may see less in private pay in general. You can move forward. Thank you. So pretty low numbers here. These are actual numbers. They're not multiples of 10 or 20 or anything. But since 2022, we've just had really a handful of cases with an increase in 2025 for cases regarding integrated community supports, with the most being 18 in calendar year 2025. And we were asked to provide month over month. So for 2025, average is about 2 per month calls that were coming in. I think part of that is there's just far fewer ICS settings than there are assisted living residents and nursing home residents. I'm not sure why else that may be. And I think I'll turn it to my colleague, Pre-Chair Redina, to move forward in the presentation.
Mr. Dina, welcome.
Thank you, Chair Hoffman, committee. So for the ICS complaints that we're seeing in those 20 cases, half of the complaints were related to discharge and eviction. There were a variety of other kind of one-off complaints, including those listed here: language barriers, access to information, response to complaints, symptoms unattended, and environment or physical plant concerns, but certainly the vast majority related to discharge or eviction. And so far, those complaints received by our office are not related to payment holds or prepayment screens that we have seen so far. And as Ms. Gaborio did detail, the vast majority of our work does exist in assisted living facilities and nursing homes, and we did feel it was very important to bring the continuity of care conversation to what happens in these settings, even if there isn't a prepayment screen happening at the moment. As mentioned, for the last few years, at least 25% of our casework in assisted living facilities have been related to insufficient cares or services that people are paying for or taxpayers are paying for that are not being provided. That's what was listed as well, the call light response times being a long time, a lack of incontinence care, missed rehabilitation therapies, medications that are administered incorrectly or missed entirely, and insufficient food and quality of food, as just a few examples. A couple of examples to illustrate what this looks like for people. A resident was supposed to get hourly checks in their assisted living facility. They fell, and nobody found the resident for 11 hours. They were just there on the floor for 11 hours. There were supposed to be hourly checks. And as we'll connect with the next slide, for a lot of residents who experience that, they're being charged for hourly checks as well. So paying for a service that they're not receiving. Second example, a resident experienced so many medication errors that they were hospitalized. We worked with the one resident who experienced this, but of course, because this resident was receiving other residents' medications, we don't know what happened to the other residents who were also experiencing the same chain of errors. The fees in assisted livings for residents who are paying privately are a big concern. And this is a full 10% of our casework in assisted living facilities. We're seeing pretty unreasonable fee increases for the same level of service. We're not talking about more services necessarily adding to a bill, but we are seeing higher costs for the same services. A lot of the new fees we're hearing about is a fee to pay by check instead of automatic withdrawal, fees to participate in activities, hospice coordination fees. That's often, we hear about $500 a month for somebody in the facility to read notes once a week, approximately, is what's happening there. And therapy coordination, very similar. We're also seeing cost increases for, again, the same services that a person was receiving. And billing is so confusing that residents can't understand the bill, our staff can't understand the bill, and staff in the facility have a hard time explaining what the bill actually is detailing as charges. We've noticed a change in the last few years. Billing offices used to be located in each facility, assisted living and nursing home. Now that's being outsourced to corporate headquarters, and so it's hard to find a person in the facility who can actually answer those billing questions. Calls are being made, voicemails are being left, but the return call is not always happening. One example of fees going up for the same services, a resident saw an almost 50% jump in service fees in 1 month for, again, the same cares that they were receiving. Nothing new was added. And to add insult to injury, the services themselves were not routinely provided. So huge jump in costs, not getting the services. And then second example here, residents at multiple facilities are calling us about a new kind of fee called a fall fee. It's $150 to $250 per fall that a resident experiences. And the service, as far as we can understand, that is provided is a vitals check, an assessment to determine if more medical attention is needed, and documentation in the resident's chart. Pretty standard practice for a fall as well. Just a quick note, you won't see a similar fees slide for nursing homes, which I'll switch to next, because we have rate equalization in nursing homes, so there can't be excessive fees or these increases for residents paying privately. But in nursing homes, in that same 3-year period, we saw a 32% chunk of our caseload related to insufficient cares provided in nursing homes. A lot of the same concerns, a lack of wound care kind of being the standout there. That's a little bit different. But that's a third of our cases related to this in these last few years. First example, a resident developed a new bed sore due to long call light response times, putting on their call light, their pendant, asking for help, and staff not coming for so long that they had a new bed sore. The Department of Health did come in after a MARC report was filed and substantiated neglect, but nothing changed in the resident's care. There was no update to the care plan, no additional staff, no plan to address the resident's call light. It just continued as it had been in a way that created this health issue for this resident. And I think this last example really pulls together multiple issues that are part of this conversation. A resident has a care plan that staff will assist them with toileting, helping them transfer in and out of bed, walking to the bathroom, toileting, going back to their bed and getting back in the bed. That's taking so long that staff decided, all the staff at the facility decided to instruct the resident to use a bedpan instead of providing that service that's in the resident's care plan that is being paid for. And you know, I think the lack of service there raises a question of the dignity of care and how we support people who should have dignity of care. It also raises concerns about future care needs. That person is losing strength, mobility, agility every time they're not getting in and out of bed to get help with toileting. And, you know, I think for staff, there's a big question here in terms of what must your shift look like? How overworked must you be if everybody in the building feels like the best answer is to have a resident use a bedpan instead of providing the service that they're supposed to be getting? So we are seeing a lot of concerns with this narrative of people paying for services either privately through lifetime savings or through taxpayer dollars, and they're just not receiving the services in a routine fashion. And we thought it was important to raise that concern here. So as this committee is deciding how to respond, this is, I think, a key part of what's happening. And that's our contact information. Thank you, Chair.
Thank you. So having you three up there, I think I'll ask this also for the other folks that are coming up today. In January, in the prepayment review, there was a slide that was called Person-Centered Improvements Underway. And the Department of Human Services testified they're expanding the work of the complex transitions team. I think it had to deal with acute transitions, I'm not sure. But have you starting to see any evidence of that yet?
Chair Hoffman, as far as the complex transitions team helping ICS transitions, we have not seen that.
Yeah, the whole point was to help people transition in cases that they were supposed to, folks that were impacted by provider closure, to help them transition. There's this complex transition team that they were expanding the work of. Have you all seen any evidence of that yet?
Not with the clients that we have at the Minnesota Disability Law Center or Legal Aid.
Okay. Parche.
Chair, same answer. We haven't seen that with the clients we've been working with.
So members, January, they were going to do this. Senator Etke.
I didn't want to cut you off, Mr. Chair. I was going to have a question when you got done with your statement.
No, you're good, because the process would keep going on this. So you set up this complex transitions team. Well, what does that mean, and who's all involved in it? And I wish that the department was here, but I don't see them out in the crowd. Do you?
Yeah, better send somebody after them. But no, a question for clarity from our testifiers here. When we're talking about the ICS cases, and on the one sheet on the graph, it showed 18, and then we get into talking about the assisted living, and we talk about 25%, and we see these percentages and the numbers. Do these all fall into that 18, or are these multiple layers? What are the numbers to kind of help clarify that, or so we know what we're talking about?
Parche.
Chair Hoffman, Senator Etke, thank you for the question. No, these are different service categories. So the 18 is specifically for residents calling us who are living in ICS settings. The vast majority of our work is in assisted living facilities and nursing homes, and that's well over 3,000 cases a year that we're working. So the numbers are much different for those settings.
Thank you. That's what I was after, is to kind of see the big picture, because going from 18 to 3,000 is a big change. So then the 25% is a lot. Thank you.
Thank you for that clarification. The other one is, when you're looking at it, where's the tension point? Because this is the thing that just keeps coming out when we talk about ensuring continuity of care. Where's the tension point? Just from what you all see as the ombudsman, and I'm going to ask the same to the mental health and developmental disability ombudsman too. What's that tension point, all parties, when it comes to ensuring continuity of care for Minnesotans? What's preventing everyone from working together successfully?
I can start, Sheriff. I think I'd highlight a couple of things. I mean, one is there are privacy laws in place for good reason. I mean, we don't want a lot of private information about vulnerable adults being shared without cause. But I think the need to keep that information within some silos does create some challenges, and it's a balancing act then between working together and maintaining that privacy protection for the vulnerable adult. And then I think there's also just a logistical challenge of how do you speedily approve services, particularly under a waiver, find a provider who can go in and have somebody go in and begin providing, for example, the PCA services that Ms. Smart referenced. There is just a logistical challenge in making that happen.
So as a follow-up to that, and then I'm going to go to Senator McQuaid, are those, and this will be helpful for us because we're looking at a continuity of care package that we're putting together. Is that, do you know, on those privacy laws, are they federal or are they state privacy laws when you said that? Do you know?
Chair Hoffman, my understanding is the Minnesota Data Practices Act is a lot of the concern here.
Thank you for that. Senator McQuaid.
Thank you, Mr. Chair. I'm looking at the slide that says approximately 10% of your casework has come from unreasonable fee increases for residents paying privately for care. Is there commonality amongst the places where you're getting these caseworks from that are seeing these fee increases? And if so, could you describe what those commonalities are?
Periche.
Chair Hoffman, Senator McQuaid, thank you for the question. We are seeing corporations that are instituting these fees, and we do also see that once one corporate chain has instituted a fee, it does tend to go to others. It does. There are a lot of facilities that then start, the fall fee is a good example. There are a lot of facilities in the last year or so that have instituted the fall fee, and that was brand new, 10 months, maybe less ago, but we're seeing quite a bit of that. So there does seem to be kind of an initial instance of that happening and then spread across the state.
Senator McQuaid.
Thank you, Mr. Chair. Well, I'm so glad you got to this fall fee. What? So that's new in the last, so like right around, we wouldn't have even been in session, or maybe we're just finishing up session when you started seeing this. So just to be clear, so residents who might have disabilities or medical events and then fall are being charged money for falling.
Ms. Periche.
Chair Hoffman, Senator McQuaid, that is correct.
Senator McQuaid.
Thank you, Mr. Chair. That can't be legal, shouldn't be legal. We might want to look into that as lawmakers. Anything you want to add about that? I'm sorry, I'm just a little taken aback by this. If you want to just expand on that at all, I'm.
Ms. Regina.
Chair Hoffman, Senator McQuaid, you know, I think it is a shocking fee. When we heard about it, jaws in our office dropped to the floor as well. And there are a number of fees that are similar that have always been part of the practice of providing assisted living care to residents. And now there are separate fees. Hospice coordination, that was just part of being an assisted living resident and having hospice come in and help provide care. And now there's this coordination fee that is hard to really understand what it's for. And I think to go back to the continuity of care question, I think part of what is so hard for residents and families who call us about these fees to understand is, if I'm paying all these extra fees, how come I'm not getting the services that I'm paying for on a routine basis? How do those two things go together?
Thank you, Mr. Chair. I mean, I know we're not in the like place blame part, and I think that's good. I am struck by conversations I think we had in this committee about bills specifically around this. And sometimes you have a bill and it seems like a good idea, and then the next year it's like a really good idea because there's more instances of that needing to be in place. I think I had one more question, which was, is there anything about the data, not the data you collect, but if there are certain facilities or certain areas or certain providers where you're getting a lot of referrals or cases from, is there a mechanism for then reporting that to MDH or DHS or something?
Ms. Regina or Genevieve, you got?
Chair Hoffman, Senator McQuaid, yes, we have regular contact between the Ombudsman for Long-Term Care and the Department of Health and DHS. We have weekly meetings with the Department of Health to elevate and escalate facilities of concern or chains of concern to identify how we can address that together.
Senator. I'm just looking at a text here, and I'm a little fumed. So
Let the
that's...
fire come out of your ears.
Do you see it coming out?
My question back would be, so are you finding that those weekly meetings and that elevation is having an impact? Is there more visits or more, oversight or anything that happens because of that elevation?
Go ahead.
Chair Hoffman, Senator McQuaid, I would say yes. Although there are limits, if the current law does not prevent certain fees, that's not something that a MARC report would get a tag for then. And so there are kind of limits baked into the law with fees being widely chosen by providers.
Senator, absolutely.
Thank you, Mr. Chair. I think one thing I would find really helpful is a list of the fees in particular that you're getting calls about, or that ones that exist. And I think there's probably a corollary ask here for some of our facilities to provide a list of all the fees that they're charging for. But it would be helpful, I think, to get a list of ones that exist or you're getting calls about that might be legal. And I'm going to use that in like a technical term because there's like legal and then there's wrong. And then also ones, so maybe if you categorize, like we know this one exists or we've heard this one exists, but we haven't, seen anything, so we can cross-check that. I think I would really appreciate a list like that.
Do you think you can follow up with that?
Absolutely, Chair. And Senator, if you do get a list from facilities of fees they're charging, we have a lot of residents who want that information too.
Senator?
Thank you, Mr. Chair. It sounds like another thing that could go on a bill, a law.
I think sooner than later. We only have like 9 more times that we get to meet. So as we start to prioritize what that looks like in the continuity of care conversation. How many? 10? I don't know. No. This is sad. Thank you for your time. Thank you for letting us know what the impact of decisions that were made. After this committee gave specifically laser-like statutory authority, and it was just like it was ignored. And that I'm going to perseverate on as a term. I think perseveration is a term I can use. Senator Fate.
Yeah, thank you, and Mr. Chair, and thank you all. Senator McQuaid touched on the second question I was going to ask around the categories of fees, but is the term unreasonable fees defined anywhere in law?
Anyone? Just Regina?
Senator Fata, if it is, I wasn't using the legal definition in the slide. It, in a common definition, feels very unreasonable to residents, families, and those of us getting those complaints.
Senator.
Thank you. No, I was just asking it in general, but that's good to know. Thank you.
Is it statute? I don't know. Is there somebody from the department that could be here to answer that question? I don't see anybody. Do you?
I think we could ask them to come down.
Okay. I think we're gonna, takes 2/3 vote to subpoena somebody to show up to our committee. I think I can get 2/3 of the people of this committee to go ahead and play that game, Senator. We've never had to do that in all the years. You know that?
Mr. Chair, they're subpoenaing and just inviting them to come down in a friendly way. And I think that, even though there's no topics that directly relate to them, the comments of this committee is an important discussion in the human services arena. And I think that maybe they're monitoring at their desk at home, but I think that things come up, and I think it's reasonable that they should have at least a corporal's guard of staff available to take questions back to the home office. So.
And to say that they have capacity, and any given time we have a hearing, there's at least 15 people up there from the department, and I see everybody in this room, folks. I tell you, when I look into a room, I look at a room, and so I'm seeing nobody there now, Senator. I've never seen that ever happen in all my years on here. This is the first time this has ever happened. So, I'm not okay. I think this conversation is so important. This tells me, Senator, about if we really cared about continuity of care, then we would have somebody in here having the conversation with us. But they're not. I'll let the rest go. That's not okay. Thank you very much for being up here. We're going to get up here now, the Office Ombudsman for Mental Health and Developmental Disabilities, Lisa Harrison Hadler and Lisa Anthony Thomas. And then we're going to go to Sarah and Ken. And then the last time this happened, it was when there was this, forget it, I'm not going to go there. As they're getting segued up.
So, Mr. Chair, do we really matter? What is our role here? So everything that we pass, they have to approve in order for the governor to do it. So are there any concerns you have about the way it's working at DHS? Some of the functionality of, 13 different programs, many other programs that the money is being withheld from, with no end in sight, where maybe the people are going out of business, perhaps people aren't getting served? Is that on your mind, Mr. Chair? And does the fact that you and I lose sleep over this, people think we get elected, Mr. Chair, to come and work on this stuff. Should we change what the marketing is? Like, we're a bunch of observers. Like, we should have blue hats. We like the UN observers, and we can report back how it's going. Thank you, Mr. Chair.
That was a good segue. Lisa Harrison Hadler, Lisa Anthony Thomas, welcome to the committee. It's all yours. For the record, state who you are.
Thank you. Thank you, Mr. Chair. For the record, I am Lisa Harrison Hadler. I am the Ombudsman for Mental Health and Developmental Disabilities. To my left here is Lisa Anthony Thomas. She is our Deputy Ombudsman for the office. And we'll just kind of jump right in here. What's happening here? Lisa, this is my nightmare. Can you fix this? Sorry, something got a little awry as we plugged in here. Well, you can go ahead and figure out how to drive this thing, Lisa. I'll get started. So, at the Ombudsman for Mental Health and Developmental Disabilities, we have a statutory mission to promote the highest attainable standards of treatment, competence, efficiency, and justice for persons who are receiving services for mental health and developmental disabilities and/or substance use disorder. Just generally speaking, we like to sort of set the table for what is an ombudsman. It's a word that not a lot of people are familiar with. I certainly know this committee is deeply familiar, but just for others, an ombudsman is an independent, impartial public official with authority and responsibility to receive, investigate, or informally address complaints about government or government-related agencies' actions. When appropriate, they may discuss findings, make recommendations, and publish reports. Just a quick little background on the history of our agency. We were established by the legislature in 1987 to address concerns or answer questions relating to services of an agency, facility, or program. We'll unpack that in a minute because it is a huge, broad swath of the social services system here in Minnesota with regards to services for mental health, developmental disabilities, and/or substance use disorder. We are an independent, small state agency. I like to refer to us as small but mighty. With less than 24 FTE, we respond to about 10,000 requests for assistance across the state, and we'll get into that a little bit more as well. Our authority is outlined in statute, and thank you all for the support and the tech side of things. Our authority does come from statute, and thank you to this committee for helping us expand availability of our services over the last couple of years to include more of the service settings and options for people with mental health, developmental disabilities, and substance use disorder. We have 3 primary teams that help us deliver on our statutory mission, which include our regional ombudsman team of 14, our medical review unit of 4, that helps process all of our death reviews and death investigations across the state, and a small support staff team to give us all of the administrative support that we need to function as efficiently as possible. Anybody can contact our office And we are not a regulatory entity, and I emphasize that we are not a regulatory entity, and we'll come back to that a little bit later when we get into some recommendations surrounding concerns that we're seeing. And as we're not a regulatory entity, that means we cannot compel compliance with our recommendations or pointing out where services are not being delivered consistent with statute, policy, or rules surrounding them. So we serve Minnesotans, again, with questions or concerns about services with an agency, facility, or program. This includes children and adults of all ages. And here, again, anyone can contact our office on behalf of themselves, family or friends, clients or others. It's not uncommon for us to get requests from legislators as well. One thing that we do like to note, though, is that while we can receive questions, concerns from anybody, on behalf of an individual receiving services, we're not adult protection, we're not licensing. We really need to have a conversation with that individual, if possible, to find out if they want our involvement, and number two, sort of what is their desired outcome with regards to this situation in their own words as much as possible. So anybody can contact us, but if they do, one of the things that we're gonna try to navigate through is how can we get an opportunity to talk directly with the client to hear from them what their desired resolution might be. And again, back to what is an agency, facility, or program, that's going to be broadly the Departments of Human Services, Department of Health, the Department of Education, all local school districts, all county social service agencies that monitor, provide, or regulate services, or treatment for mental health, developmental disabilities, or substance use disorder. And then the facilities or programs where we've had some additions over the last several years are going to be residential or non-residential programs, or an acute care inpatient facility in a hospital that provides clients with services or treatment for that is required to be licensed, certified, or registered by the Department of Human Services or the Department of Health. Also, recovery residences, an unlicensed service that has been added to our purview, as well as peer recovery support services provided by a recovery community organization. And I know that there's a lot to kind of get into the weeds there. I'm not going to do that for today's purposes, but to just really emphasize how broad our scope is with regards to the social services system. And at last count, that was something like 70 or more different service lines or settings that would be under our purview. So we provided a little bit of information about our case growth in general over the last several years. You can see between 2022 and 2025, there was just around a 30% increase. We are now right around 10,000 cases a year, new cases a year, not to mention the ones that have ongoing work throughout the year or even multi-year investigations. And if you want to go to the next, Lisa. And you can see there is some fluctuation by month. That's very normal for us in terms of people that take vacations or services that may have sort of different seasons to them as we go throughout the calendar. An example of that might be our work in special education and with schools during the summertime would be significantly decreased. This just gives a little bit of information about, we work kind of at different levels and different in depth based on the cases that are coming to us. Most cases, because of those limitations in service capacity, we are working through kind of an individual consultation and assistance, providing resources, self-help suggestions, advocacy, statute, rule, whatever it might be to help people resolve the situation themselves. If that's not successful, they can definitely come back to us and we can look at taking on additional actions. We've got serious injury reviews and death reviews. Both serious injuries and deaths are required to be reported to our office within 24 hours. And then that sort of brick red color at the top would be the number of new investigations that we're opening on a given month. So with all of that background, really wanting to focus the rest of our time today on those issues that we're seeing with regards to fraud mitigation efforts, and really kind of breaking that down for you into a number of thematic areas. So we have gotten 61 unique requests to our offices reporting concerns with fraud mitigation efforts, how they're impacting individuals receiving services. They tend to fall into a number of sort of themes or buckets that I put together here for you. One that may not come as a surprise to you, given the testimony of our predecessors this afternoon. The most include concerns with regards to integrated community supports and settings, ICS. There. And I really want to emphasize when we're talking about ICS, what we have identified, and I think some others have alluded to, is there's sort of this disconnect between the provider and the service in ways that there may be some potential to regulate the licensed service, but there's really not clarity with regards to enforceability of people's rights in the setting, in the provider-controlled setting or that apartment. And so that's not dissimilar to some things that we saw that led to assisted living licensure a number of years ago, where the service was regulated, but the setting was not. And we have had many conversations with DHS about sort of where there are opportunities to try to identify some enforcement capacity with regards to the setting, and primarily people being vulnerable to eviction without really great resources other than sort of general landlord-tenant law. And I think that there's been a number of conversations and a willingness to engage in those conversations, but we have not been successful in identifying what would that solution be from the department's perspective. We do hope to continue those conversations because, again, as an ombudsman's office, we can be tenacious in advocating for our clients and our clients' rights, but at the end of the day, we can't compel compliance. And so if a provider is telling us, okay, we're just going to close our doors rather than delivering the service or providing the notice that we have an obligation to, if they're electively closing their business, there's not a lot that we can do to try to persuade them to do the right thing by the client in these sets of circumstances in the absence of any regulatory or enforcement arm or mechanism. Sort of the next most common thing, go back. The next most common is with regards to concerns involving services not provided. And that really runs the gamut from what we're seeing in community residential settings, assisted living settings, as the Ombuds for Long-Term Care just mentioned. We are seeing that also with regards to individualized home supports. Really across the board, there are situations in which sometimes it really is just a workforce shortage issue. A person is supposed to be receiving one-to-one services in the community for a period of time, but has not had those hours delivered month after month without changes to the service plan. Other times it is just a bold, sort of brazen lack of providing services that continue to be billed, including in some cases we'll get to examples of trying to falsify records with clients. We have seen some situations, and I broke these out into a couple different categories for you, separating out residential, wherein people are losing their home, from non-residential. Actions related to fraud mitigation, payment-related issues that have resulted in services being suspended or threatened to suspend. In residential settings, that is 18. People who have been impacted in that way, people who have actually lost their housing due to fraud mitigation efforts, prepayment audits, or some of the other things you've heard here today, is 8 identifiable individuals. And then we have also seen, I heard mentioned 4 deaths where there was some connection to a report of either services not provided or some other element in this. What I can say to that and to all of these, but particularly to emphasize with regards to the deaths, is those are still under investigations. Those death reports and investigations take some time in order for us to get all of the required records. We can certainly expedite those things.
Oh, you're good.
Okay.
I was just going to wait for you to pause so I could say Senator Abler.
Oh. Well, thank you. That was just a pause, too.
Did you raise your hand?
I did, yeah.
Okay.
Hey, that was funny. Anyway, your thing was funny. This isn't funny at all. Can you just elaborate a little bit on, there's a series up there on this interrupted payments business. There's 2 kinds of interrupted payments, which I guess we can't get any counsel on, Mr. Chair, if we had further questions, because there's nobody here to answer the question. Maybe you look a little harder. You want to borrow my glasses? Would that help? Anyway, so there's two interrupted payment things. There's this totally unforeseen delay that happened right around New Year's, where 2 weeks and in some cases 4 weeks of payments were not given to people without notice of any sort. And Mr. Chair, I believe without any involvement of the providers in planning this. Anyway, that's an editorial, sorry, I'm wandering afield. And the other kind is where there's a credible allegation of fraud, where payments are suspended indefinitely with no chance for the provider to feedback. Can you comment on those elements as you list interruptions of services and housing loss and even the deaths to the best of your ability?
Ms. Harrison.
Because it's on our mind. It's, our whole group here is equally interested in knowing about this, and we're quite appalled, frankly, but just to give you a hint, but go ahead, I'm sorry.
Ms. Heather.
Yeah. Mr. Chair, Senator Abler, thank you for that question. We are working as fast and as furiously as we can to get at some of that. I think for the purposes of today, pulling this more broadly, but trying to sort of further break that down, I think the challenge in doing that is we get to smaller and smaller numbers, just data practices, implications that might lead to people being identifiable. And so I think that was part of the thinking behind preparing this for you today, but we can certainly go back, Lisa, and we can identify where there's further refinement. Part of the challenge with this when we were first approach to prepare for having this conversation prior to session was we were having to retrofit our data collection system to be able to capture some of this as it was happening in real time. And so we've done that and established some processes as we go forward to make sure that we're collecting things to the granular level that might be helpful to you all and to others. But for today, this is what I have, with a commitment to making sure that we can try to break it down for you as much as we're able within the confines of data practices going forward.
Well, thank you, Mr. Chair.
Senator.
And so I do really appreciate that part. Just it seems like the impression we've gotten, even talking to, the OIG, and we have the right to do this, and all is well, and just with, I don't know, I don't want to, impugn their motives, because I just don't understand their actions. And I believe their motives are well-intended, but the interruption of services on a vulnerable adult could cause great harm. And homelessness itself wouldn't cause great harm, but it would certainly be a problem for individuals who are vulnerable. And so if they find a couch to land on somewhere, well then, Mr. Chair, no harm happens. But that's not the design of the system that we have. And the department, what's it called, the safe transitions or something? Are you familiar with that? The new program, I don't think it's even operational yet, even though they kind of bragged about it, that it started in October. So we're just troubled by that. And so we're squarely behind you in worrying about this. Are you tracking also companies that have closed that no longer deliver any services to people? And I don't want to give you, that's actually that's my first question. And also, like in NEMT providers that have been interrupted from doing services. I know one company was stopped from doing 3,000 rides a month, and they have no idea what they did wrong. They've been around a long, long, long time, and they're not the newfound tourist fraud people. So is that the kind of stuff you're tracking? And I wish, and please do, so I'll let you just comment. And I don't want to make you break your privacy, but I mean, this is like the biggest catastrophe in human services in Minnesota. There was all this worry, I guess I'll keep going. There was concern about the Fed stopping $2 billion. But here, in fact, we have stopped relatively that much with a 2-week delay and then with these invisible investigations that go on. So you get the flavor. So just comment as best you can, and I gotta think it keeps you awake at night.
Ms. Harrison-Adler.
Yeah, Mr. Chair, Senator Abler, it's been really sobering, I think, and it's sometimes terrifying thinking about what the implications are for our clients and for people receiving services. To get at one element of the question posed, we are aware that the department has put forward that they are doing a lot of things to try to make sure that individuals are not negatively impacted by that. When we have pushed back and said, okay, so you're doing a lot of the things, can you tell me one thing? one tangible thing that is not referring them to the case manager and shifting the responsibility solely to the case manager. I have not gotten a tangible answer to that question as of yet.
I'll let you go, but Mr. Chair, that's like headline news.
You think if Allison Chen was in the room, in the audience, that she'd be, questioning our folks that are testifying before us right now?
Yeah, I'll let somebody else could talk, but we have made this, you and I together over our time since 2017, have made this committee about the people. Independence, quality of care, and that's been what we've done. And the bills you're bringing forward here, you can't tell what they are. It's all about the good of the people. And then just through some administrative action, through, well, I will call it thoughtless administrative action, hasty, not including even you all and the people in this room who did actually bother to come today, who are watching at home. I'm just worried about it. So I don't mean to perseverate, to use your word, Mr. Chair, but we have actually people that can track that. So that for the first time they're in front of us, that's why I guess I'll let you go with part two.
It's all in that aspect of the continuity of care. This is what's happening, and these bullet points that are up in front of us are a sad reality of what that hammered approach was versus what we gave. This committee gave them authority, laser-like authority to do their thing. So keep taking us to the end, and then we're gonna get to the next group of people that are here. Ms. Hadler, Ms. Harrison Hadler and Anthony Thomas, thank you for, take us back.
Yeah, thank you, Mr. Chair, members. I think that the rest of this is really getting at sort of the vein of the questions, which are what are the impacts to people? We can collect all the data for you. We can report on all of that. But this comes from our database entered by our regional ombudsman and our medical review staff. And I just wanted to highlight a few of what these actual stories experienced by actual people look like. And so in one case, the client called about the ICS being shut down with very short notice. The client says the provider lost their license and the new property management said that they weren't going to allow ICS services in that setting anymore, and that everyone had to leave across the board. The client says that they're trying to work with their case manager as best they can for new places, which again includes housing. We know that there's already a lack of affordable and accessible housing in Minnesota for people with disabilities. And so that case manager may be trying everything they can, but can't conjure an affordable apartment out of thin air in a moment's notice. And so the client's experience is that, they can't tell if the case manager is doing anything. They're not being very responsive. Another example would be a client who has a case manager contacting us for concerns with a client who's getting services from X provider. He gets individualized home supports and homemaking in his apartment. He's been complaining of staff not being there for the allotted time, inconsistent staffing, and that they're ultimately neglecting his care. The case manager said he has reported to Mark repeatedly before and brought this to the company's HR, as well as in this case, a report to OIG for fraud without resolution. Another example that shocked me when I pulled this was a bit of a new one for me. A client on a CADI waiver is receiving individualized home supports from a licensed provider, and the provider is instructing the client that they need to pay a $10 fee for every episode of services. PCA who's forging the client's name on timesheets and pressuring the client to purchase items for them. This was specifically asked about in the request for our testimony if we were seeing it, and the answer is emphatically yes. We've had a hospital social workers reach out to our office inquiring about a client whose provider is experiencing a DHS, what they called payment freeze, but a payment withhold and a credible allegation of fraud situation. Hospital says that the provider got the notice and then immediately dropped the individual off at an emergency, citing that they were not given resources or a timeline of the investigation and thus could not afford to continue delivering services without payment. And the client remained in the hospital absent any medical necessity while the case manager attempted to find another placement. To one of the questions that was posed earlier, we were notified via licensing lookup information that license, community residential license setting, subsequently did close. And this last one, kind of bookending the discussion about ICS. We had a client who contacted us saying they had just found out that they needed to be out of their apartment by the end of the month, that at that point was but 10 days away. They lived in an ICS setting. They were told upon move-in that rent would be paid in exchange for ICS services. The landlord showed up at the apartment unannounced, and along with a prospective resident to give a tour of the apartment to someone else. And the client had no knowledge of what was happening, no previous awareness, no previous notification that this would be happening, until the landlord showed up at her door to tour the space with another prospective tenant. And then this client subsequently learned, as was alluded to by one of the previous testifiers, that the rent that she had paid in had not been forwarded on to the landlord for the last 5 months. Again, received no prior or even formal termination of services or eviction notice.
So where does the legal authority lie to compel a company to resolve these complaints?
Mr. Chair, thank you for the question, and I'm not trying to dodge it other than to say I think that's why we're all here today. Is that right now we're not seeing very clear enforcement mechanisms with sufficient capacity to be able to intervene in these situations where particularly the ICS landlord is operating in ways that may be inconsistent with legal protections for tenants in those settings, but without a regulatory entity to sort of referee that, nor capacity for our clients to get access to quality legal services to work through sort of the landlord-tenant process. And I want to give all of my appreciation to the Minnesota Disability Law Center and Mid-Minnesota Legal Aid, who I think is trying to step into that space as much as possible, but I think there's just so much more demand than capacity.
So if the, and we'll get Ken and Sarah start working your way up here, but the thing that gets me is services provided under waivers. We do our Medicaid plan, and when you see one state Medicaid plan, you see one state Medicaid plan, right? And the entity in charge of that is the Department of Human Services, right? And so if you're saying we can't figure that out, then I guess we need to figure that out, folks, that this seems to be missing. This was the finger pointing between 144G and 245D, right? It's the same thing, and it's just, it bothers me. And I wish the department would be somebody. I mean, they get 12 to 15 people that show up at a hearing, but today they just decide not to show up. And yes, I will say it over and over again. This is about continuity care. This is about the impact that their decisions were made after we gave them authority. This committee, actually, in the House committee, the other body committee, and now they're nowhere to be seen. That shows to me that there's a lack of accountability. And yes, I said that. And so I would wish that we could get that answer. And if the answer is, and maybe Ellen Smart can tell us about that later, or I got Matthew Bergeron, I'll ask him, you know, if there's something missing that we need to put in statutory authority, then by all means, this is the committee to do it. So thank you for your time. Appreciate that. Senator Abler. No, Senator who was first?
Mayquade. I talked already. Do you want to go?
Yep, Senator Mayquade.
Mr. Chair, I think one thing that's also coming up for me as we hear this is at no point was there a duty to inform, right? Nobody was informing tenants, clients, I mean, case managers. It's kind of coming in through these, and you're the snapshot, right? So like for every 4 people you hear from, how many people do we not hear from? And, you know, we just had a hearing on Friday at the Federal Impacts, the subcommittee, and I didn't know, and before that there had been the threat to withhold, you know, $515 million from the federal government to Minnesota per quarter, so it'd be like $2 billion a year. Right. And one thing I'm thinking about is that if that happens, like, are we going to have this but magnified a million times over, right? So like, what do we need to put in place so that no matter who is doing the thing, that the people who are impacted get at least notification at the very least, and maybe resources to our folks who are supporting supporting them as things move along. So that might be something we want to look at.
I like that. Actually, I think that makes sense for us to do, Senator Abler.
Well, thank you, and thanks Senator May Quaid. And, Mr. Chair, we sit here, and I'm gonna get one of those blue hats, just so I can at least feel better about being a spectator and an observer and report back to some home office. I'm just really frustrated. I don't even know where to go. But so what we're talking about here was actually self-inflicted by Minnesota. You can decide what entity did it. And then the specter of what might go on from an equally unthoughtful entity at the federal level. I mean, it's just anyway. So I just want to actually, at the risk of agreeing with my good colleague there, which she nearly threatened me in the Education Committee, even though I'm at risk of agreeing, she said today in the Education Committee. Whatever. It was pretty funny. But anyway, so it seems, Mr. Chair, if only we had an entity to whom one could complain about these violations of policy that are egregious. Oh, we might. OIG. That would be their job. I think that if you have a problem, and I think Ms. Grafstrom and other people would say, we don't want to take responsibility for people not paying rent. That's not our people. We got good people that are trying to do their best. These outliers, we have no time for that either.
Yeah.
And I would think that if there is the job that entity would be to track down people that are blatantly not doing what's right, blatantly not paying rent for 5 months. And Mr. Chair, they actually would have to answer your question, because you're the chair. You might say, in this case, what did OIG do? I think that'd be a question you could ask specifically, or at least you could ask them in the privacy world to say, would you please on our behalf ask the OIG what they did with this case? If they even had the mechanism to hear about it. I think that would be something, instead of chasing down people with a de minimis complaint that they don't even get to tell anybody what it is. I'm working on legislation about that, Mr. Chair.
Thank you.
Hoping to fix it. So, Mr. Chair, and maybe is that something, if the chair asked you, could you ask that question about what they would do if someone didn't pay the rent for 5 months, and then somebody get kicked out?
Mr. Chair, Senator Abler, I would be delighted to be part of asking and trying to develop solutions for any number of these questions.
So be it. It's a great question. I'm asking that question. Thank you.
Yeah.
All right. That's good. Thank you for your question asked. Now we just get it answered, right? Hey, Matt, you want to work your way down here? Bergeron, too. We got 3 chairs. So are you guys. This has turned into a pretty good conversation. Sarah and Ken, welcome. Just for the record, state your name and
Thank you.
and the floor is yours, and then Bergeron's coming. I got tons of questions for Bergeron. You guys, if we go over, you guys okay? That is Sarah.
I'll kick it off. All right. Good afternoon, Mr. Chair and committee members. For the record, my name is Sarah Grafstrom. I'm the Senior Director of State and Federal Policy with ARM. I'm here joined by my colleague Ken Bentz, ARM's Director of Research, Analysis, and Policy. For over 50 years, ARM has represented hundreds of disability waiver service provider organizations across the state. Our members provide services in each of the 87 counties, supporting over 20,000 people through a variety of different services. The most common being a service called Community Residential Services, provided in a provider-controlled home called a Community Residential Setting, or a CRS, commonly referred to as a group home, and services provided in individual's own home called Individualized Home Supports, or IHST. These services and many more are an important part of the ecosystem that supports people with disabilities to live where and how they choose. Changes to one service have a profound impact on the entire spectrum of services. Over the past few months, we've seen fraud prevention focused on 14 services that have been designated as high risk. My colleague Ken Bentz will go into more detail about those services that our members provide, who they support, and the barriers that have been put in place for providers to provide these services. But before I turn it over to Ken, I want to highlight the impact on the entire spectrum of services. ARM's members offer an array of residential services to people, with very few of our members providing just one type of service. There is no one-size-fits-all approach when it comes to meeting the needs of people with disabilities. I highlight this as a way of saying that while fraud prevention measures are targeted at the 14 services deemed high risk, disruptions impact all services and all people. To share an example, at the beginning of the rollout for the up to 90-day prepayment screening, many providers were experiencing significant delays in payments by DHS. This had significant consequences for the people we support. One member had to inform their staff that they would not be able to make payroll, resulting in multiple staff members quitting before noon that day. The provider was left with a situation of needing to move individuals who were living in a community residential setting, a service not deemed as high risk, to an emergency room because they did not have the staff to keep them safe. The barriers to maintaining continuity of care under these conditions are significant. Providers cannot access bridge financing easily, particularly nonprofit and small rural agencies operating on thin margins. We are in a more difficult position due to new public perception on financing for services. Lenders are less likely to extend lines of credit. One example of this from Greater Minnesota of a provider who had a banker bristle at her request for bridge funding because, in his opinion, she was being investigated for fraud. ARM had to connect with the banker to tell him that indeed the provider had done nothing wrong, but just happened to be caught in the payment withhold process. Other barriers include staffing instability, increasing when payroll uncertainty becomes public, leading to workforce attrition in an already strained labor market, individuals at risk of losing housing stability when providers cannot sustain operations, emergency departments in hospitals becoming the backstop when residential staffing collapses, and counties and case managers left scrambling to find placements in a system that already lacks capacity. The ultimate goal of fraud prevention should be to protect the people who rely on these services for their day-to-day, not unintentionally reducing their access to the services they need. We must find a way to filter out problematic and fraudulent actors from longstanding disability service providers who have served their community for decades and ensure the continuity of care for people. I'll now turn the testimony over to my colleague Ken Bentz to break down some of the data and demographics of what we're seeing.
Mr. Bentz, welcome to the committee. Please introduce yourself and proceed with your testimony.
Thank you, Mr. Chair. Good afternoon, committee members. And I am Ken Bentz. I'm the Director of Research, Analysis, and Policy at ARM. Sarah has done a nice job of illustrating the fragility of the system and how interconnected the web of services is, and the level of impact disruptions in some services can have on others, whether they are high risk or not. So to help set the stage, you all know that the disability services field has been under strain for many years, and that's putting it mildly. We come to you every year with the latest grim statistics. When we surveyed our members at ARM last spring, before any of the recent challenges have materialized, they reported an average of 98 days of cash reserves, so roughly 3 months, with a range of from 0 to 365 days. So it wasn't surprising to us when providers started reporting severe financial hardships and, in fact, missed payrolls, as Sarah said, following the unexpected delay in payments the last couple of months. We also know that many nonprofit providers rely on donations to cover their operational expenses, and philanthropic giving has been on the decline. So this is already an industry in crisis. Providers have responded to the dynamics of these changing investments from the state and increasing costs over the past several years by suspending, or in some cases closing, programs and homes. The COVID years were very stressful for our providers, and nearly half reported reducing their capacity in residential services in the years immediately following the pandemic. And even in our most recent survey, still about 1/3 reported reducing capacity in the last year, citing low reimbursements, future uncertainty, and staffing challenges as the reasons. And speaking of staffing challenges, our members reported a turnover rate of 51.5% among direct support professionals in 2024. 51.5%. That's the highest rate reported in at least 7 years. This indicates, of course, a very high level of churn in the DSP ranks. And in fact, over half of the DSPs who left in the first 6 months of their employment. Our state has a current licensed capacity of about 14,000 in community residential settings, but the ability to support this capacity is strained due to our chronic staffing shortages. Individuals living in their own homes are particularly vulnerable to service disruptions that we've been hearing about already today. As opposed to the community residential setting, which is required to provide 24-hour plan of care, is billed at a daily rate, and services provided to individuals living independently are billed in 15-minute units. The two most common services that an individual living independently in their own home may access for support are the IHS, or Individualized Home Supports, and also night supervision. Both services have been designated as high risk. Individuals living in their own homes may find themselves going without services for multiple days if a provider does not have the resources to meet their staffing needs, and you've heard examples of that today. Getting into some numbers, there are currently 1,800 providers licensed to provide the IHS Individualized Home Support Services across the state, including about over 83% of ARMS members. And there are 1,400 providers licensed to provide night supervision. Through a recent data request to the Department of Human Services, we learned that 7,575 people across the state received unit-based services such as IHS or night supervision from multiple providers. So of course, the total number of individuals receiving the services is much larger when you add in the number of people that access services from just one provider. These numbers illustrate the fact that the universe is large and the impact is immense when disruptions occur. For individuals who are accessing services in their own home, the need will look different for each person. For some, it is a few hours, a couple of times a week of support to ensure weekly tasks are being met. But for others, it can be a plan of care of up to 24 hours every day that supports someone to maintain living in their own home. And what happens if that service is disrupted or goes away? And again, you've heard those stories already today. So the fallback for individuals on a disability waiver who live in their own home may be moving into a provider-controlled setting, such as a community residential setting, group home, if one is even available. Minnesota has had a moratorium in place now for CRS settings since 2009. There are exceptions available. And then the recent announcement of a 2-year freeze on new 245D licensed providers and a freeze on current 245D providers from adding any new service lines, again with exceptions available. But that will make options for people seeking new services more limited. These options are further exacerbated in greater Minnesota. 81% of all licensed IHS providers are located in the metro area. And you've just heard about the ICS service from some of our predecessors here. There are 483 enrolled sites in the entire state, offered by 243 provider entities, and 87% of the settings are in the 7-county metro area. Those settings represent the total of 2,846 approved units, and again, 88% of those units are in the metro area. If an individual loses their provider, finding a replacement, especially outside the metro area, will be very difficult. When legitimate providers close, people lose services that support them in maintaining their housing, stability, relationships, and trusted staff. We must find a balanced approach that ensures program integrity without putting people at risk. And with that, I will turn it back to Sarah.
Thank you, Ms. Grafstrom.
Thank you, Mr. Chair. To conclude, ARM wants to stress that we understand the significance of the fraud happening in home and community-based services, and we understand that swift action must occur, but we cannot overlook the need to ensure continuity of care and the sustainability of legitimate providers across the state. There must be collaboration with the provider community to preserve our current and very heavily strained system. And we just want to thank you for the opportunity today to allow ARM to present, and happy to answer questions.
Thank you. If you wouldn't mind maybe staying at the table. Oh, Senator Abler. We have one more testifier on the list. We have Mr. Bergeron, so we can either do questions now or we can do questions after his testimony. Okay. Mr. Bergeron, welcome back to the committee. Please introduce yourself for the record and proceed with your testimony.
Thank you, Mr. Chair, committee members. For the record, my name is Matthew Bergeron. I'm a healthcare and government relations attorney with the law firm of Larkin Hoffman. And I'm here today on behalf of the Residential Providers Association of Minnesota, or RPA-MN, which represents small community-based residential waiver providers across the state who support Minnesotans with disabilities and older Minnesotans in customized living settings, community residential services settings, and in integrated community supports programs. RPA-MN was asked to present today to share its recent experiences of small providers who deliver residential services to Minnesotans. To say the last 9 months have been challenging would be a staggering understatement. Every day, thousands of people with disabilities and older Minnesotans wake up in homes where stability is not an option. It is the foundation of their health and safety. They rely on residential waiver services to help with medications, meals, behavioral health supports, crisis response, and routines that allow them to live safely in the community. For many of these Minnesotans, housing and their services and their care provider are not separate issues, but they are an interconnected system. The staff who support them, the setting they live in, and the structure of their daily lives are tied to their wealth and their health and well-being. And over the past year, that stability has been shaken, not just by the fraud investigations and the resources drained from our system, but what has happened to residents when enforcement actions move forward without sufficient continuity of care protections in place. When payments to a residential provider are suddenly withheld, it does not simply pause a revenue stream. It destabilizes a person's home, daily routine, staff relationships, and support networks nearly immediately. For individuals with complex medical, developmental, or behavioral health needs, those disruptions often lead to hospitalization, emergency placement, regression, long-term trauma, and as we heard earlier today, even instances of death. Since its formation in 2021, the Residential Providers Association has sought to be a partner with DHS and the legislature to ensure individuals in need of residential levels of care and support are able to receive the high-quality services safely in the settings of their choosing. RPA-MN vehemently opposes fraud in our human services programs and strongly supports the law enforcement efforts to investigate and prosecute those who are stealing from our most vulnerable Minnesotans. And yet, while the headlines have focused on fraud, the Providers Association believes that the turmoil of the last year has shown a bright light on a broader systemic problem. Far too many of Minnesota's Medicaid programs are not appropriately developed in statute or in regulation, and as a result, it is not uncommon for service recipients, providers, lead agencies, legal aid attorneys, and even different administrations within the Department of Human Services to have a different understanding of what the law is, how a program should function, and what compliance should look like. As a healthcare attorney, I can tell you that regulatory ambiguity not only creates loopholes for fraud, but it creates risks for providers who are working in good faith to provide services under what can only be described as less than ideal circumstances. All it takes is for one of the stakeholders I just mentioned to think in their opinion that you're doing something wrong, and then an agency can be shut down. The services recipients' care jeopardized, and an already overtaxed human services system stressed further. In recent months, we've seen that play out quite visibly, where dozens of residential providers have had payments withheld as part of a fraud investigation, and hundreds of Minnesotans have been suddenly without care. Let me be clear. The Residential Providers Association does not doubt for a minute that over the last year, DHS has appropriately identified, investigated, withheld payment, and supported the prosecution of fraudulent providers. And some of the comments made earlier today about instances and individual complaints are shocking, saddening, and are absolutely the kinds of things that should not be happening. But we also worry that through this process, the current investigative system has, or may very well, have caught up providers who never intended to defraud the system, but potentially to struggle to navigate the programs in which they operate. The state has a number of mechanisms to hold providers accountable: licensing sanctions, enrollment terminations, fines, as well as the temporary payment withhold. And unfortunately, the temporary payment withhold is the one tool that we've seen that the providers don't have the opportunity to file an appeal, to seek some kind of clarification, to really even understand what they've been alleged as doing wrong. And so that creates a payment withhold and a stop in operations nearly immediately, with really no opportunity to proceed going forward. These payment withholds will go on for months at a time, generally in my experience representing individual providers over 10 years in private practice. Many times no investigation results in a licensing action or a criminal charge or a payment termination, because the agency goes away and things kind of move on. And so that creates situations where agencies, as we saw with the prepayment review, don't have the cash flow to continue to provide services for weeks or months while they hope to try to resolve some kind of, misunderstanding. So I think there's very real concerns through this process that the continuity of care, that the safety of lots of Minnesotans receiving these services has been interrupted in a way that maybe was unnecessary in some of those settings. Or similarly, that some of the tools available, particularly in the federal regulations for a Medicaid agency to impose a temporary payment withhold, lift it for good cause as defined in the federal regulations, including the ongoing care and the need of somebody while they're being transitioned, and then be able to continue their investigative operations and sanctions, haven't been utilized as fully or at all to the extent that they could be. And so that is a big part of this process that the residential providers was hoping to bring forward today, is some of the tools that are in law that aren't being used, and some of the considerations that maybe aren't as forthright. And lastly, I just wanted to say, because I'm cognizant of the committee's time and the long day you've had, I think it's really important. I just do want to also note that amongst the small providers, there are a lot of providers of color, immigrant providers, new first-generation American providers. These entrepreneurs many of them began as direct support professionals and built culturally responsive services for underserved communities. And in recent months, many are feeling particularly vulnerable. When regulatory scrutiny identifies or payment actions occur, providers of color describe a fear that they're being disproportionately targeted, or that language barriers or cultural differences are being misinterpreted as non-compliance. Whether or not those disparities are intentional, and I'll note that that's outside of even just the interaction with the regulatory agency, providers have shared that they're afraid to speak publicly, afraid to challenge case management decisions, and afraid that a single complaint could end their business and disrupt the lives of the individuals they're serving. This fear is not healthy for a system that depends on transparency and partnership. And so while small providers are not asking for for any less accountability, they're asking for clarity, consistency, and collaboration. They're asking for placement practices that prioritize safety and appropriateness. They're asking for payment systems that recognize the fragile cash flow of small community-based businesses. And they're asking for an environment in which providers from every background can feel respected and treated equitably. So with that, Mr. Chair, I thank you for the opportunity to share my client's thoughts, and I'm happy to answer any questions.
Thank you, Mr. Bergeron. We're going to go to the Senator Makway.
Thank you, Mr. Chair.
And then Senator Abler.
I appreciate you bringing up at the end the tools that are available that aren't payment withholds or investigations that occur while still allowing services to be provided to people who are receiving services. I have a really specific scenario to ask a question about. So let's say I'm in an ICS setting and I'm authorized for 10 hours of services, well, let's say 5 hours of services a day. Do I have the right to decline those services?
Mr. Bergeron.
I'm not, pardon me, Mr. Chair.
Yeah.
Senator, I'm reluctant to answer because I'm not super confident. My understanding is that yes, you can, but I'm not reluctant, so if I have been assessed for those needs and I don't want that individual in my unit that day, that's my understanding. There are some complexities to the ICS billing model as it relates to like an average daily number of hours over a period of time and what that means for on a day in, day out billing versus services provided basis. That's probably more granular than I'm able to answer, but I'm happy to help facilitate that as well.
Senator.
Do any of the other testifiers want to answer that question?
Ken, you want to answer? I'm sorry, Mr. Benson.
If I may.
Nice to see you, by the way.
Nice to see you very much. Another example in IHS, individualized home supports, which are an own home service, the recipient is authorized for a certain number of hours, and they can refuse, I don't want that today, but then the provider can bill for that. So they have this set of authorized services that they're prepared to deliver, but they don't necessarily deliver all of them if the recipient isn't in need of it that day or has something else to do or whatever. So there are instances where the recipient can refuse the service.
Thank you, Mr. Chair. And in that case, does the staffing for the services decline? Does the cost of that go away?
It does not. Sorry.
It's okay, Mr. Benson. I'm good.
It does not.
Thank you,
Senator.
Thank you, Mr. Chair. I think one of my I'll disclose this to the world, one of my pet peeves is concept creep. And I think as we've kind of had all these conversations about, what we can do to address, program integrity in the state of Minnesota, we've kind of taken everything and made it fraud. And I think that there are instances where we have waste or inefficiencies, or where we have unclear standards in law. Like, I'm not aware of a point in which maybe a client can just decline services so many times where then maybe the hours get adjusted, right? And so we actually have some tuning up to do, and we have to have nuance with what we're doing with both clients, Minnesotans, and with the providers, because these are people we're talking about, and they all exist in that nuance. And I think our system is very reflective of the fact that we've tried to be responsive to a group of people, and then we make a new thing, and then there's a group of people who didn't get included, so we make a new thing for them. But we've really kind of built a hodgepodgey house, and I don't know if we can get from one side to the other, because all of our contractors were different people. And so maybe it might be a good time to look at the whole thing. And I don't want us to find inefficiencies or waste or unclarity. And I don't want us to say that then that's fraud. And I really want us to be cautious about kind of saying this is a place where it doesn't work, and we'll fix it, versus it's fraud. So because that's always going to be the argument for getting rid of all of it. And I don't want us to end up there.
Mr. Chair.
Good point to that, Mr. Bergeron.
So, Mr. Chair and Senator, I think you raise a really good point there, and it calls into question a little bit, I think, some of the needs assessment process at the front end. If somebody's being assessed for 8 hours a day of needing certain types of services and is routinely declining them, that calls into question the accuracy of that assessment and kind of how the system has been built in order to assess somebody in order to ensure some services or some kind of placement or some kind of setting, versus a situation where maybe there's more inaccurate assessment of their care level needs as it relates to, either a provider controlled setting or an own home setting, and the other financial barriers or burdens that are blocking some of those kinds of assessments.
Thank you, Senator Abler.
Well, thanks. I'm just shocked Mr. Bergeron's disparaging men choices the way he is. I don't know. Sorry. It's my personal joke. Is that funny? No, actually he's not. But it's just amazing how the whole assessment process, on top of everything else, is just bizarre. That lately, in particular, Mr. Chair, you've heard from multiple people that had an individual with significant needs, that they've had those needs for literally 8-10 years, and suddenly their services are cut in half.
Yep.
Because somebody says, nah, you don't. And then if they continue to get care, they go, you're committing fraud by hiring this privately or continuing to get services. And it's just, I don't know. It's just amazing. If only I could have asked one of the department staff about that, Mr. Chair. So my real question, just to anybody up there, and maybe all of you, but so given in the withhold thing, you've heard me opine, and I'm working on some legislation, and I would love all your help. Maybe you got, hopefully that email came through, I don't know. But and that's not, if you want to share it with people, I'm just looking for advice. We have to make the withhold thing work. Like the incredible allegation of fraud business, there has to be a thing. And it even says a tip on a hotline could be a good reason, like seriously. And even to clarify that error is not fraud, and a few things like that, and a chance for people to get to react. But so with the 2-week delay, which was even surprising to some of the staff at DHS, I understand, like, you're killing me, Smalls. How many people, can you comment about the effect on the industry? How many, have a number of them gone out of business? Have a number of them laid off staff so they're not serving as many? Could you just comment on that? I know some people were very hard pressed, and are people going out of business yet, or they're about to go out? It's been 2 months now, or actually a month and a half. It's 2 months.
Mr. Chair, Senator Abler, so I'm aware of one provider up in northern Minnesota that did end up shutting their doors. I think they had around 500 clients that they were supporting, and they ended up going out of business. For our members, as things were kind of rolling out, as Ken stated in his testimony, many of our members did have cash reserve. So what we had heard as we were talking to our folks is we have about 30 days, but if this goes on any longer, we're in real trouble. And that was kind of the benchmark that we heard from. A few that I mentioned in my testimony were in crisis, did miss payroll, but they're still in business and they got some of those staff back now. But it was around that 30-day mark that providers were saying anything longer and we're gonna be in big trouble.
Senator Abler, there was a gentleman who had to borrow $275,000 at 17% interest just to stay afloat, and he can't anymore. And so that's a real story. And Representative Gander over in the House said if we could tap into the funds that we had set aside a few years ago, you know, the question on the table is how do you help folks like that get through this while the system figures it out? I just, not okay. Senator Abler's a follow-up.
Mr. Bergeron, I think, was going to comment.
Yeah.
He was leaning forward as though we were about to come.
Mr. Chair and Senator, in speaking to my client and its members, the experiences that Ms. Grafstrom represented are generally about the same. I know there was some further confusion in the kind of second 2-week period over claim submission dates, and that created a heightened or an exacerbated problem. What I will say that's kind of important to remember going forward is even as claims are now paid on a 2-week basis, assuming there's no additional operational or implementation issues going forward, agencies will never get caught up at 2 weeks, right? And so to the extent agencies that had cash flow sufficient to get over that, or cash reserves sufficient to get over that 2-week or for some 4-week window, those have been exhausted or are substantially depleted. And so it just underscores the heightened vulnerability of the provider infrastructure.
Oh, yeah, Mr. Chair, and I'm just about done, but I mean, I don't know. I mean, losing 2 weeks of cash flow, like forever, when they go out of business, then they get the last 2 weeks. Yay. So they can do some settle-up bills or something. I remember Senator Rasmussen asked how many were actually found. It'd be interesting to have an ongoing update on how much harm has been found. And I'm going to just opine on my side that the people who were, my son's a deputy sheriff, and he says, we don't catch the smart ones. He pulled over a person for a taillight and they had a gun on his passenger seat. Like, seriously, put it with the bananas in the back seat. So I think people that are bent on fraud are going to be kind of smart about it. And I don't know that the optimum rubrics are going to find, you know, they know how to randomize. I mean, I think that we're not catching the smart fraud people. And I think the ones, there's some, Jordan, you were talking about that you notice some of the expenses are lower because some of the people have decided to go to a less risky business now as they do fraud in some other state or somewhere. But maybe it would be horrible if all this was for nothing. Anyway, thank you, Mr. Chair.
We, in the last 3 years, this committee gave specific laser-like statutory changes for them to do their job. 2009, I remember traveling up to a place with a certain individual from St. Paul looking at a pile of papers because the system was doing things that were right, but the system failed. And man, that turned into what is called the Jensen Settlement Agreement because they couldn't, and you remember that, the system failed. And in this case, it's our job to bring the system back into checks. And so if there's a priority that we do, I think this committee does it. I got anybody else? Thank you very much. This has been a good hearing, and it's an unfortunate hearing. But thank you very much for your time. And a letter will be going out to the department from me if anybody else wants to sign on to that letter.
Mr. Chair, I think that your name is powerful enough on that. But I just, if you can just inquire of people to let us know how they see this safe transitions or whatever, if we can learn more about that.
Natasha Merson and Josh Berg were part of that, weren't they? Wasn't that the acute transitions thing?
No, it was in the
complex?
No, it was in the deck of stuff from the last time the department came and talked to us, and the commissioner was here. And there's a safe something thing when there's an interruption in money, there's a safe transition plan. I'll find it for you, but I think we should hear more about that. And and make sure it's just not for
I
looks.
think it's the
I
complex
think it's for looks.
transitions. I think, yeah, we'll get to that. Thank you,
But
Senator.
it's as a result of these changes, the
Yeah.
withholds, et cetera. So thank you, Mr. Chair.
Thank you. We are
Good-
adjourned.
Good hearing.